5 seconds to go. Start. This shall dispose of above mentioned 4 revision petitions filed by the tenant qua 2 premises upon which he entered as a tenant with effect from 15th January 2017 under 2 separate agreements dated 1st December 2016. The main facts are being taken from CR number 8023 of 2019. The common gamut of facts as can be culled out from the pleadings of the parties are that the respondent is the owner of the 2 properties mentioned in the petition situated in the buildings of Messrs. Roop Square Private Limited, known as Roop Square Complex, Ghumad Mandi, Mahal Bhagat, Tehsil and District, Ludhiana. The petitioner had taken the top floor and the 4th floor of the premises on rent from the respondent landlord via 2 separate written agreements dated 1st December 2016. The rent for the top floor was agreed at the rate of rupees 1 lakh per month along with 5% increase per annum. The rent for the 4th floor was agreed to be rupees 4 lakhs per month with a similar increase of 5% per annum. The duration of the said tenancy was fixed to be 9 years. As per the allegations, the petitioner paid the rent for 5 months with intermittent defaults in case of premises on top floor and thereafter defaulted in payments. Almost similar has been the position qua the 4th floor. The respondent landlord alleges that he had verbally requested the petitioner for making the payment of defaulted amount. After request, some payments were made. However, again, the default was started and is still continuing. As a result, no rent is being paid to the respondent landlord, although the petitioner as a tenant is enjoying the property. However, he has not been paying even the electricity charges or any other taxes and charges leviable by the government. On the contrary, the respondent landlord is being forced to pay the GST leviable on the rent, electricity charges and other charges leviable by the government. As a result, the respondent landlord had filed 2 separate petitions under the Punjab Rent Act 1995, in short, the Act for Recovery of Possession from the petitioner for non-payment of rent, as well as claiming his personal requirement so as to expand his business. The petitioner tenant appeared before the rent authority and filed the written statement. However, the petitioner also filed application stating the same to be under section 22 of the Act, in which it was prayed that since the respondent landlord had not given him the notice in the prescribed form as required by section 22 of the Act, therefore the eviction petitions itself were not maintainable and therefore deserved to be rejected. But the rent authority dismissed the same in both the petitions wide order dated 26th October 2018. However, since the petitioner tenant had also filed the written statements, therefore taking into consideration the pleadings of the parties, the rent authority framed the issues for its determination wide order dated 14th March 2019. Aggrieved against the above said two orders dismissing his applications for rejection of the eviction petitions passed by the rent authority, the petitioner tenant filed two appeals before the appellate authority questioning the order passed by the rent authority. Similarly, aggrieved against not ordering immediate eviction of the tenant and framing of issues in both the petitions, the respondent landlord also preferred two appeals before the rent authority. Therefore, the appellate authority considered four appeals, two filed by the petitioner tenant and two filed by the respondent landlord. The appellate authority dismissed the appeals filed by the petitioner and held that the application for rejection of the eviction petitions had rightly been dismissed by the rent authority. In the appeal filed by the respondent landlord, the appellate authority held that since the rent has not been paid by the tenant and the default continued even during the pendency of the proceedings before the rent authority, therefore, the tenant was liable to be evicted for non-payment of rent. Hence, the appeals filed by the landlord were allowed. However, the matter was remanded to the rent authority to grant an opportunity to the petitioner tenant to pay the up-to-date rent to the respondent landlord, failing which the rent authority was directed to pass the eviction order without carrying out any further proceedings. It is against these four orders passed in two different eviction petitions that the present four petitions have been filed by the petitioner tenant. Stop.